Yeah.
So am I audible properly?
Yes. Yeah.
Okay, sir.
So, first of all, I welcome all the participants for today's webinar. This is being organized by Assam Rajiv Gandhi, of Cooperative Management, AGUCOM. For those of you, most of you already are known to me, and for those of you who don't know, I'm Dr. Bora. I'm presently the HOD in charge of School of Law and Public Policy at AGUCOM. Many of you perhaps are still also not very familiar with the university. So I'll say a few words also. The Assam Rajiv Gandhi University of Cooperative Management is established by the state government of Assam. It's wholly controlled by the state government of Assam. Presently, we have management, commerce, IT, and law as well. So under the School of Law, Public Policy, we are having the LLM course and the PhD course as of now. The LLM is of 1 year only. The first, I think, state university, apart from the National Law School in Guwahati, which has a 1 year LLM course. So that's about me and my university. And what now, coming back to the today's webinar, I think this entire COVID-19 situation has given us a lot of opportunity to think over a lot of things, our life, relations, career, education, all those. As we say that the necessity is the mother of all invention. So like this entire situation, this lockdown situation has forced us to think about other means of delivering education. And I think webinar is, I'm also quite new to this thing because now these video lectures, online lectures, this webinar thing, they're all coming up. So I think such situations which has been posed by this COVID-19 situation could not prevent any of us, including teachers and the students especially, from seeking education. So I think this webinar is a small step by the AGUCOM family in this regard, and we shall be organizing many more such webinars in the near future. Now I would like to introduce our we wait for some time now speaker for today's session. She is Ms. Amlanika Bora, who is presently the assistant professor at the School of Law at the Presidency University, Banglore. Apart from being a faculty, she was also earlier associated with other legal institutions in Bangalore, like the CMI University, Ramaya Law College, as a faculty member. Now today we have invited her to deliver a lecture on the topic, as you can see, that is the Doctrine of FRUSTRATIon under Indian Contract Act and relation with COVID-19. I won't be saying much on this topic, as I have already invited a guest who will be sharing her views and thoughts with us on this topic. So I guess without saying much, I will hand over the stage now to our esteemed speaker, Amlanika Bora, request her to take over from here.
Yeah, thank you, sir. A very good afternoon to all of you.
Hello.
Present here today at the webinar. Hope all
fine.
of you are fit and fine and enjoying homemade food, right? Okay, I would like to extend my sincere thanks to Dr. Deepam Bora sir for organizing this webinar and making me a part of this. And before I start talking about Doctrine of FRUSTRATIon and COVID-19, just I want to give you a glimpse of a particular picture that you can see here. Just have a quick glimpse of this particular picture. Yes, can you relate yourself with this? Yes, what do you say? Can you relate yourself with this? If not, then I'm sure that you are not from legal background, right? The answer is yes, then definitely you are from legal background. Yes, this picture I would like to dedicate to all of us, okay, including me. So this is us. You can see this is what the people thinks about us, and this is the reality that you can see. That's in the ocean of legal magazines, in the ocean of case laws, in the ocean of recent happening of the incidents. This is us. Just okay. So like as you can see that COVID-19 happened, right? And it's like it's a pandemic as declared by World Health Organization. And this is a public health issue, as all of you know. But what we are doing today, okay, we are relating this with doctrine of frustration. Like we cannot escape from all these issues, right? From the day-to-day activities, we cannot deviate our path from all these day-to-day activities, and we have to somehow relate and correlate with all these events that's happening around us. For example, another example I would like to give. All of you, I think, know that in Vizag there is a gas leak incident. It happened, and us, the legal fraternity, have to relate that with absolute liability. We have to think about Bhopal gas leak disaster. We have to think about MC Mehta cases, right? So that is us. And I think because of this, okay, we all of us need to be very proud of our profession that help us to keep ourselves updated with the recent happening, and that gives us the platform to know the legal norms, right? The case laws and everything. And thanks to this platform, online platform, that is giving us an opportunity also to talk about what is happening around us and how this is related to the law, the legal principles and all. Okay. So now, as we all know that World Health Organization has declared the novel coronavirus a global pandemic, and a state of public health emergency has been declared in most of the countries worldwide. And there is no doubt that COVID-19 has had and will continue to have an adverse impact on the global economy and on the performance of the contracts. Right? And on 24th March, the government of India ordered a nationwide lockdown for 21 days in the first phase. And look at us today. We are on 50th day of the lockdown, counting a total of 80,000 COVID-19 cases, awaiting for the next order with some modifications that is going to be declared on 18th of May. Right? And also discussing about doctrine of frustration in relation to COVID-19. Anyways, so during this lockdown, the supply chain, the domestic and international travel, the business operations are disrupted, and many people and business are unable to fulfill their existing contractual obligation. And along with that, on 19th February 2020, White and Office Memorandum, the government of India has clarified that the disruption of the supply chain due to the spread of COVID-19 should be considered as a case of natural calamity, and force majeure, please keep in mind, force majeure clause may be invoked wherever considered appropriate. Okay, so this point is a crucial point that all of us should know, that on 19 Feb 2020, the government has clarified this particular point, that wherever necessary, the force majeure clause need to be invoked by the contracting parties if they are not able to perform their contractual obligations. Okay, I am repeatedly telling this point because we are going to use this particular point in our later part of the discussion. So this is how this doctrine of frustration, along with force majeure, is relevant and very, very important for all of us to know and to understand. Okay, because we cannot think about our life without any contractual obligation, right? So that is the importance of this doctrine of frustration at in today's scenario, at the current juncture. Yeah. So before I talk about doctrine of frustration and COVID-19, okay, I just want to have a quick glimpse of what you already know, Okay, the basic idea, the fundamentals that we are going to use in today's discussion, right? So the basic questions are that all of us need to know, and we just quickly, we have to remember that what is agreement, what is contract, what is void agreement, what is breaches of contract. So I believe all of us have a clear-cut idea about this concept, but then also for our better understanding, I just want to have a briefly, I want to tell about this. So when I talk about agreement, I have a pen with me.
Hello, sir.
Right?
Dipam sir.
So I want to sell this pen to
screen
Namrata.
share to I think off koi those here. Enable koribo lagibo.
In the webinar.
Participants screen sharing.
So I want to sell this pen to Namrata. I'm saying that Namrata, I would like to sell my pen to you. Namrata said that yes, I would like to buy. And I said, okay, for that, please
share option to
She said, okay, take it. And I have given that to her. So this is an agreement, right? It is a meeting of mine that I want to sell, she wants to buy. And for that, she is giving me consideration in the form of 10 rupee note, right? So that is an agreement. Coming to the contract, what is contract? That when that agreement is enforceable by law, that is a contract. So in this example, you can see that yes, there is a contract, valid contract. Coming to void agreement, what do you mean by void agreement? As you have already studied in the Indian Contract Act, so void agreement is that agreement that is not enforceable by law, right? Say for example, this pen I have stolen from Dipam sir. Okay, I have stolen from his house. So and I want to sell this to Namrata.
2-3 minutes we can wait and then we can start.
The very object of this particular agreement is illegal, as you can see. So that will be considered as void agreement because we have not reached to the position of formulating a valid contract, right? So that is void agreement. Coming to details of contract, what do you mean by details of contract? When one party will be free from the contractual obligations, right? Then we call that as details of contract. Okay, so the details of contract will arise when there is a termination of the contract, or when there is the contract has been fulfilled by both the parties, right? Or say for example, when the contract is frustrated, right? So in many occasions and there are many ways how the details of contract will be there. Okay, so I'm not going much about or I'm not discussing much about all this concept, only for your reference and so that you can relate our talk with Doctrine of Frustration. I'm giving you a brief idea about this.
Hello.
So just a request.
Sir, I hear the noises. So Dipam sir, I think you can mute all the participants. Then I will unmute myself.
Mute all of let's go to participants, right?
Yes, sir. Manage participants and mute all.
Yeah. Yes. So force measure. Okay. So in the beginning of the discussion, I told you about the force measure, right? And I'm starting this about the frustration with force measure. Why? Why I'm not starting this discussion with doctrine of frustration? Why I'm directly coming to force measure? Okay, that you are going to know in a moment, right? So now, what do you mean by force measure? So force measure is a French term, and the literal meaning of this particular term is superior strength. Okay, it means superior strength means that the human being will not have the control over such happening of the event. Okay, that is force measure. So it means that if something happens today, if say for example a flood happens today, okay, or there's a heavy rainfall, so we don't have any control over such happening of such events, right? Then it will be considered, as you can see, the superior strength, right? That will be considered as force measure. And according to Oxford Dictionary, it is mentioned that it is a force measure means unexpected circumstances such as war that can be used as excuse when they prevent somebody from doing something that is written in a contract. Okay, so it means according to the Oxford Dictionary, it is also we can see that the force measure also includes warlike situation. In case of warlike situation also, we cannot have any control, we cannot prevent such event, right? Even if we want, say for example when Kargil war happened, can we control that? Can we say that we want to just we want to just control that particular event. We want to roam around as if there is no war. Can I do that? No, we don't have any control over such happening of such incident, right? Then simply we can say that the force majeure events are those events, okay, which are unforeseeable, which are unavoidable, and not the result of the defendant's action, right? So the force majeure is such kind of event that cannot be foreseen, okay, that can be avoided, okay, that cannot be predicted. So the example, if you ask me the examples of force majeure event, then I will say that, okay, act of God, natural disasters, war or warlike situation, labor unrest or strike, epidemic, pandemic will be considered as force majeure event. Okay. So this is all about force majeure, and we are going to apply this force majeure in our later part of our discussion. Okay. So as you can see here, I have mentioned act of God as an example of force majeure. I have mentioned strike as the example of force majeure. So here you can think that then how the force majeure is different from act of God, or you can say vis majeure, that all of you know that vis majeure is known as act of God. So here the slight difference that you can find here is that act of God or the vis majeure, when you talk about, it is very narrow. It is a narrow connotation, right? But when you talk about force majeure, it is having a wide interpretation, okay, that includes act of God along with other kinds of events that the people cannot control. I hope this part is clear to all of you. Yes. So coming to the next part, how this force majeure has been arranged in our contract law, in the Indian Contract Act 1872. Okay, so the force majeure has been placed under Indian Contract Act under Chapter 3 and Chapter 4 of the Indian Contract Act. Okay, so when I talk about Chapter 3, that is more specifically where this force majeure has been placed. Not, you cannot see the word force majeure definitely, but yes, if you see the wordings of the section 32, then definitely I would say that yes, that is the illustration, or that is the like involvement of force majeure in the Indian Contract Act under section 32. Okay, so section 32, as all of you know, that talks about the contingent contract, the contract, the performance of which depends upon the happening or not happening of certain events, right? So when you talk about this contingent contract, guys, please keep in mind that if anybody wants to invoke force majeure clause, okay, under this section 32 of Indian Contract Act, then in the written contract there shall be specific mention about the force majeure clause, okay, with the specification of such events. It means that, say for example, if I have entered into a contract with Meghali, I can see Meghali here, she is also participating. Okay, so if I want to have a contract with Meghali that I am going to sell her a tan of rice as she is getting married, right? So she wanted a special 10 quintal of rice from me. Okay, so I have entered into a written contract with her. Now, if I want to invoke force majeure clause, right, then I have to specifically mention in that particular written contract that if this event happens, if there is heavy rain, if there is flood, then I will not be liable for non-delivery of the rice to Meghali. Okay, so it means we have to specifically mention that force majeure clause in our written contract if we want to invoke that clause with respect to our breaches of contract or to escape from the contractual liability. Okay, that is one thing. The second thing that is more important for today's discussion, that is section 56, that talks about impossibility of performance of contract, or you can say the doctrine of frustration, right? So if you see section 56, that also includes force majeure, but that force majeure is dehorse the contract. Okay, so when I talk about dehorse the contract, it means that we in the written contract don't have any specific provision that talks about that if this particular event happens, we will not be liable. We have not written anything in our written contract. Okay, but say for example something happened, but we have not mentioned in the contract that if it happens we will not perform. We have not mentioned that. Then what will happen? Whether we will be liable to give compensation to the other party? Okay, no, we still have an option in our hand that we can invoke section 56 and we can claim for doctrine of frustration. Okay, so it means that when in the written contract there is no mention of the force majeure event, then we have an option in our hand that we have section 56 that we can claim for exemption of our liability. Okay, so that is how the force majeure clause has been, or force majeure provision has been erased in the contract, Indian Contract Act. And we are going to see more about this section 56 and doctrine of frustration. Okay, hope this point is clear to all of you. Yeah. I just want to confirm, sir, can you see my slides? You can see my slides, right?
Yeah.
Okay. Yes. So coming to this point, the most important, what do you mean by frustration of contract? Yeah, this word is very fascinating for me, frustration, and how come the contract can be frustrated? Okay, so think about us. Say for example, today I have given my consent to Deepam sir that I will come for the webinar. Okay, then there is a sudden power cut, I don't have internet, then what will happen? That will be a panic situation for me, right? Definitely I will get frustrated that what's happening. One side there is lockdown, another hand I don't have current, I don't have internet. How I'm going to live my life, right? I would be frustrated. Similar, okay, with respect to contract also. So when you talk about frustration of contract, what will happen that without a default of the party, okay, the contractual obligation has become incapable of being performed. Okay, and it changed the very foundation of the contract, then we will say that yes, the contract is frustrated, right? So that is the frustration of the contract. If we don't go by the wordings of section 56, I'm talking about the general meaning. What do you mean by frustration of contract? Okay, so what I'm saying is that the parties to the contract, they don't have any control over the happening of the event, but then also something happens, some wrong happened, some incident happened, some event happened, because they are not able to perform the contractual obligation. Okay, and because they couldn't perform their contractual obligation during that particular time when the unforeseen event happened, the very foundation of the contract has been changed. Okay, then we will call that as doctrine of called it as frustration of the contract. Okay, so it is very, very important. One is that the foundation of the contract must be changed. Okay, say for example, I will give you an example. Yeah, so I can see Pinky does. So Pinky is also a participant in this particular webinar. Just an example, I want to take your name. Yeah, say for example, Pinky was supposed to get married on 28th of April. Okay, so he has booked one marriage hall. Then this lockdown happened, right? They couldn't celebrate her marriage, and they thought that, okay, I will postpone my marriage. Okay, so now what will happen? Whether the speaker does able to pay that money to the marriage hall people, or what will be her liability? Because on that particular specified day, if she will not get married, definitely she has to postpone, right? Then many other situations will also arise with along with that. So now what will happen? In such situation, we have to see, the court will see whether the very foundation of the contract has been frustrated or not. If there is another chance of performance of the contract, then definitely we will not call that as frustration of the contract. With respect to this example that I have given, please think to the end of this particular discussion that what would be the answer for that particular situation. Okay. So coming to the next part. Yeah. I would like to give a glimpse of the evolution, basis, scope, and ambit of doctrine of frustration. Okay. So here, as you can see, the doctrine of frustration has some relation with some legal maxims. The first one that I have mentioned here is clausula rebus sic stantibus. That means things does standing. Okay. So it had the obligation under a contract are binding as long as matters remain the same as they were at the time of entering into the contract. Okay, so it means that once the matter of the contract has been changed, you cannot force the parties to perform the contract because they didn't think about performing of that particular contract in such changed scenario or circumstances, right? So definitely there will be some exception, or there will be some kind of situation that they can exempt from their liability. Second one, that has a relation with respect to doctrine of frustration is that lex non cogit ad impossibilia. Okay, so it talks about that the law does not compel a man to do that which he cannot possibly perform. Okay, so it means that the law will definitely not force a person to perform an impossible act. Okay, so say for example, as in the previous example I have talked about providing rice to, say for example, Dipamsa, okay, 10 quintal of rice to Dipamsa, and then flood happened in Jorhat district where I stay. Okay, because of flood I cannot go to Dipamsa's place to deliver the rice. Now the court will definitely not say that no, you have to go, you have to swim, and you have to go to Dipamsa's place to deliver the 10 quintals of rice. Definitely not. The law will not force us to do something which is impossible to perform, right? Then the next one is that nemo terniter ad impossibili. So the meaning is that no one is bound to perform an impossibility. Similar, because these are the legal maxims that is related to doctrine of frustration. Okay, so these are the legal maxims that you can relate with doctrine of frustration when we talk about the frustration of a contract. Yes. So quickly, I would like to tell you about the case law from where this particular doctrine was evolved. Okay, I'm not going to talk in detail about the cases because that you will get in book, or you can just do the research. India Kanun also you can find it, right? Manupatra also you can use that research part. I'm giving to all of you. Please go through these cases if you don't know. If you already know, that is well and good. Okay. So yeah, the case where this doctrine of frustration was formulated by the court was Taylor versus Caldwell. Okay, Blackburn Zay has formulated this particular doctrine that is we call as doctrine of frustration. Okay, then again we have another case, Krell versus Henry. Okay, that we have Robinson versus Davison, where it has been specifically mentioned that when the parties to the contract becomes incapable of performing the contract, then we will say that yes, the contract is frustrated. Okay, and the parties will not be liable for non-performance of the contract. It will be considered as an exemption. Yeah. So the general rule that we can see from here is that the general rule is that once two parties, okay, two persons entered into a particular contract, they are bound to perform their contractual obligation. That is a general rule. But as we know, the law is not absolute. There will be always exceptions, right? So the exception is that although they are bound by the contractual obligation, but there is always an implied condition that the party shall be excused from the performance of the contractual obligation if it becomes impossible to perform. Okay, so it means if some unforeseen event happens, then they are not bound to perform the contractual obligation. So that is the exception. Yeah. So as we have discussed, as I have discussed about this evolution and all, what do you think? What is the basis of doctrine of frustration? And you can see from this particular picture, actually, what do you think? What is the basis of doctrine of frustration, as we have already discussed? Any one of you can just unmute your mic and you can give me the answer. Any one of you. You have to just unmute yourself and you have to give the answer. What is the basis of doctrine of frustration? What do you think? Any answer? Yes.
Impossibility of performing the contract.
Yes. Yes. Very good. Who gave me the answer?
Bhargav, because
yes, Bhargav. Thanks. Yeah, as he's very intelligent. See, it is written here, and you can see from the picture also. The basis of doctrine of frustration is nothing but the impossibility to perform the contract. Right? Thank you, Bhargav.
Welcome.
Yes. So coming to this section 56 of Indian Contract Act. So the section 56 has the first, in the first part of section 56 of the Indian 56 of this particular section, you can see that it talks about an agreement to do an act impossible is itself void, right? So it has three parts. This section 56 has three parts basically. And the first part talks about that if any person contracts to perform any impossible act, that is completely void. Okay, we're not going to look into this particular first part of this particular section because it is very clear. So say for example, now Bhargav is having stomach pain. Okay, I say that, okay, I know some magic. You give me 500 rupees and I will cure you, right? That is my contract. Then give me 500, I know some magic and I will that magic to cure from this particular stomach pain. Okay, that if you see that very foundation of the contract, that is itself void, because magic, how can someone know magic, right, first of all, and how it can be a curative like way to cure someone from any particular disease. So the very foundation is definitely impossible to perform. Impossibility lies in the very foundation of the contract, and definitely that particular contract is void. Okay, the important point that we have to look here is that the second part of section 56 of Indian Contract Act, okay, that talks about that a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promiser could not prevent unlawful, becomes void when the act becomes impossible or unlawful. And this is the most important part for doctrine of frustration. Okay, and this we have incorporated the English doctrine of frustration in Indian Contract Act, right? So it specifically talks about that when after the formation of the contract, if any unforeseen event happens and because of which the performance of the contract becomes impossible, one thing. The second one is becomes unlawful, right? And the promiser could not prevent such impossible event or unlawful event, then the contract becomes void, right? So that is doctrine of frustration. As already we have seen the evolution and about the basic concept of doctrine of frustration. I hope all of
Hello.
Yes, sir.
Okay. Having a technical issue. She is having a sudden power cut, so she'll be joining back very soon. Just wait for now. Till then, I can see over here there are almost 65 participants in this discussion. So I'd like to request all of you, if possible, I will share my email ID with you. After this program is over, to send me feedback on this webinar if possible. And we'll also be sharing the e-certificate of this program, but that will take some time, a week or so. I think that is coming back online again.
Am I audible, sir?
Yeah.
Oh, okay. So because of power cut and my internet connection was interrupted, and I think I can start now.
Okay.
I just gave the example and it happened.
Okay. Please stay on.
Yes. Yeah. So yeah, I was talking about Section 56 of the Indian Contract Act. Yeah. So I told you already, right, that after the formation of the contract, if the contract becomes impossible because of certain events, happening of certain events, okay, or if it becomes unlawful, okay, performance of the contract becomes unlawful, then what will happen? The contract will be considered as void, okay. So it shows that we have incorporated doctrine of frustration under Section 56 of Indian Contract Act, right? So when you talk about impossibility, as you can see in Section 56, impossibility means that refers to cases that the human being cannot have any control, the parties cannot have any control, okay? And it should not be because of the fault of any of the parties, okay? That is also very, very important. So that is the crucial part that we should know when we talk about the doctrine of frustration under Indian Contract Act. I think that point is clear to all of you. Now, coming to this point, that who will decide that the doctrine of frustration can be applied in a particular contract, okay? Or who will decide that, yes, the contract is frustrated? Who will decide that? Definitely, if there will be any such kind of issues that is there between the parties, then definitely they will go to the court, and court will ultimately decide that whether in that particular contract and whether there is any particular situation that we can term as frustration of the contract or not, okay? Beside that, definitely the court will take into consideration the beliefs of the parties, the knowledge of the parties, the intention of the parties, everything as an evidence. But the ultimate conclusion to be given by the court, looking at the circumstances of that particular case, why the parties could not perform the particular contract, okay, whether it is actually a frustration of the contract or not, the ultimate decision would be formulated by the court and not by the parties. And as I have mentioned, that the intention, knowledge will be taken into consideration as an evidence, okay, but it will not be the ultimate factor to decide whether the contract is frustrated or not, okay. So for that, it means that for case to case, the situation of the frustration will be different, okay. So it will vary from case to case, and ultimately the court will look into the circumstances and will give the verdict whether the contract is frustrated or not, okay. And once the court decides that the contract is actually frustrated, there is no need of giving any notice to any of the parties, that why they have not given the notice to us if it is frustrated on all. This kind of allegation any of the parties cannot put against the other party, okay, because as you can see, Section 56, it clearly talks about that if it is impossible, the contract would be void. So there will not be any question of sharing of any notice, okay, providing any notice to the other party once it is frustrated and once it is declared by the court that yes, the contract is frustrated, okay. Now, important point that I think as of now all of you understood that what is doctrine of frustration, right? So for that, to apply doctrine of frustration, you have to have certain preconditions. In all the situations, definitely you cannot apply the doctrine of frustration, okay. So what are those preconditions? As you can see, I have written certain points. Don't look at those certain the points. Look at only the picture. As the picture says everything, it is always easy to remember a particular event or anything. It may be a case law if you look at the picture. Okay. So now, if you see this particular picture, what you can see, the first boy is very happy, right? It means we need as a precondition, there shall be a valid contract. The second one, smiling a little bit. So it means that some part of the contract has been fulfilled. Okay, some part of the contract has been performed and other part needs to be performed, right? So that is why he is smiling a bit. Then this comes that something happened and now they are not able to perform the contract. That's why he is a bit tensed. Okay, then if you see this fourth boy, okay, so it means that they even cannot mitigate or they cannot such happening of subsequent event, and there is no even alternative way of performing the contract. That is why now he is completely tensed at how they are going to perform the contract. As you can see, the last one, okay, so he is completely frustrated because he is now not able to perform the contract. He is not having any alternative mode of performance of the contract, right? So these are the preconditions for applicability of the doctrine of frustration. It means if your agreement is void from the beginning, then there is no question of applying doctrine of frustration. Okay, so these are the preconditions to apply doctrine of frustration. Now, coming to the exceptions, is there any exception to doctrine of frustration? Like, is there any situation that we cannot apply doctrine of frustration even if we have all this precondition? The exceptions will always be there. And what are those exceptions? It means if the contract is only not possible to perform, like literally, okay, because you are sick, say for example, okay, or say for example today there is a Assam Bandh declared by the state government or ASU, because of which you cannot perform the contract for one particular day, right? So then what will happen? Then you cannot say that yes, that is an example of doctrine of frustration, okay, because next day you can perform. The second one is that if there is any alternative mode of performance of the contract, okay, just say for example, I will give our example only, the teaching community. So all the students are, say for example, in Rajiv Gandhi University, they are students of Rajiv Gandhi University. It means they have a contract with the university, right? So now because of lockdown, they're not able to come to the university, right? But there is an alternative mode of teaching or imparting knowledge, right? And that is an online mode. Now, if it is not happening, then the court will say that, okay, you cannot say that that is a frustrated contract if you're not performing your obligations, because we have an alternative mode, right? So if there is any alternative mode of performance, then that is as exception of doctrine of frustration, okay? The next one, if that happens, if the impossibility to perform the contract happens because of the negligence of any of the parties or fault of any of the parties, right? Then also we will not call that as doctrine of frustration or the contract is frustrated. No, definitely not. Yeah, so these are some illustrative cases or examples you can use that can be used as how or when the contract can be frustrated. So definitely in case of war, okay, non-occurrence of any contingent events, right? Then subject matter being destroyed, subject matter of the contract definitely. Then unforeseen supervening circumstances, death or incapacity of the party to perform the contract, right? And the government or administrative action due to change in legislative policies. So these are some illustrative examples, okay, illustrative cases where you can say that, okay, if it happens, then the contract will be considered as frustrated. And also, again, I'm repeatedly saying it always depends upon the case, okay? If in the contract it has not been mentioned that when it needs to be performed, okay, then what happened for 1 year, then definitely the contract is not frustrated, because we have not said that I have to complete the contract or I have to perform the contract within a year. I have unlimited time because the time period has not been mentioned, right? So definitely it will depend upon the cases with respect to whether the contract is frustrated or not. Now, coming to the force majeure clause and its importance, as I already mentioned about force majeure clause, and I'd already told that if any person wants to invoke force majeure clause, that shall be specifically mentioned in the contract. If the contract is silent about the force majeure clause, then the parties cannot claim the force majeure as exemption to exempt from the liability. Okay, so that is very, very important. So whenever, if say for example, after completing LLB, you're going to join corporate, or you are, say for example, drafting contract for any company, then be very specific while including or incorporating force majeure clause if you're entering into any contract with other party, and make the force majeure clause wide enough so that it can include anything, like any pandemic, any epidemic. Okay, if your force majeure clause says only about the act of God, or say for example flood, right, then the other party will say that no, lockdown will not be considered as act of God, right, or this coronavirus will not be considered as act of God, so definitely you are not exempted. So that can be the situation. So when one person is incorporating the force majeure clause, it is very essential that they shall be very specific enough, and they should give wide interpretation or wide connotation to that particular clause. Yes. Now coming to the important question, that whether COVID-19 is a force majeure event, what do you think? What is the answer for this? Any one of you, can you tell me? I have discussed all the points that you can relate with COVID-19. What do you think, whether COVID-19 is a force majeure event or not?
Yes, it is.
Yes. Okay. So you can use that force majeure clause in any of the contracts?
Yes, we can.
Even if your contract that you have entered into other party is silent about force majeure, then also? What do you think?
Yes, ma'am.
Yes. I would say that no. Say for example, Moon Achari Nishi. Okay. Nishi has entered into a contract with Moon. Okay, I can see them. So now Nishi is saying that, okay, because of COVID-19, I am not able to perform my contract. And I say that this is a force majeure, so I will not be liable for this. Moon said that no, your contract is silent about force majeure. There is no clause of force majeure. You will be liable. What Nishi would do now? What do you think? How she is going to exempt from her liability? What will be the answer? Anyone, quickly. It's okay if it is wrong. Just try.
As you have already said, the government, if the government will declare something, then there will be like a exception to that. The thing that whatever you have given, that 4 points, that the government is declared that there is a lockdown period, then
Yes.
it will be an frustration of contract. If that is
frustration of contract. Yes. Yes, correct. So partially correct. So see here, he's very intelligent. So he said correctly that yes, because now with this COVID-19 force measure, even if your contract is silent, right? But then also you have another provision, section 56. So if your contract is silent about force majeure clause, as I'm repeatedly telling you that to claim or to invoke force majeure clause, your contract must have that particular provision. Otherwise, other party will say that no, you are not exempted. So now you take the help of section 56 of Indian Contract Act. Okay. So section 56 says about that you can take the exemption even if your contract is silent. So you will say that now doctrine of it is a case of doctrine of frustration. Even the government has declared lockdown, even it is a pandemic, and although our contract is silent, but then also as it is unforeseen and it becomes impossible, you use the wordings of section 56 and we will be exempted. Okay, so the answer will be that even if your contract is silent about force majeure, then also we have another weapon in our hand, and that is section 56 of Indian Contract Act. Okay, so with respect to COVID, even the Indian courts recently, in the case of State Cooperative Election Authority versus Ishwar, has specifically mentioned that the COVID-19 qualifies as a force majeure event. Okay, but the parties need to invoke it depending upon the situation and also the terms of the of the contracts need to be taken into consideration while giving the benefit of force majeure to the parties to the contract. Okay. So what do you think? What are the remedies available as a consequence of force majeure event? What can be the remedy of force majeure event? Even if force majeure event happens, okay, and in your contract there is a mention of the force majeure event. What can be the remedies that are available to you? What do you think? What will happen? What kind of remedies you will get? Any one of you, quickly. Yes. Okay. So let me tell you. Yeah. Yes, yes.
Ma'am, some kind of concession we will be able to get.
Okay. Yes.
Like in schools and colleges, the admission fees have been decreased. So it would be a benefit for the public.
Okay. Yeah. So that will be there. Okay. But the thing is that the question is basically with respect to a contract when there's an existing contract. Okay. And it could not be performed because of the force majeure. Then what will be the remedies? Okay. So the question is basically for the contracting parties. Okay. Say for example, between us there is a contract. Okay. To say for example, sell my cell phone to you, and I said that I will sell my cell phone to you on 28th of March. I couldn't sell because of this lockdown or COVID-19. So now and we have mentioned specifically about the force majeure clause. We have mentioned in the contract that if some kind of pandemic happens, if war happens, if any kind of natural calamity happens, then if the person, any party is not able to perform the contract, then he will not be liable. That provision has been given under the force majeure clause. Then what will be the remedy for the parties to the contract? That is my question. So the remedies will be that the parties, it depends upon the parties to terminate the contract. Okay, they can terminate or they can wait for the event to like get over, and after that they can perform the contract. Okay, and if they want, they can just discharge from their liability. Okay, those are the remedies, those are available for the parties to the contract depending upon their wish and will, and also depending upon the court. Okay, so that is the one thing. The second one is that what if the contract does not have force majeure clause? I have already addressed this particular question, but then also I want to know from you, what do you think that if your contract is silent about the force majeure clause, and I'm repeatedly telling you, force majeure clause means that specifies the events, war, natural calamity, okay, then pandemic, epidemic, that because of that you are not able to perform your contract. That is a force majeure clause. So now if your contract is silent about force majeure clause and this lockdown happened, this pandemic happened, then how you are going to exempt from your liability? What you will do? What will be the answer for that? Yes, yes, very good. Yeah. So section 56. So it means that I think all of you understood about this particular section 56, Doctrine of Frustration. Also the force majeure, which is the most debatable topic of contract law now at the present juncture. Okay, so that's all. If you have any queries and quick questions, you can ask me.
Those who want to ask questions, they can unmute their mics and ask questions to each speaker.
Is it clear to all of you? Yes, is it clear to all of you?
Yes, ma'am.
Clear? Section 56 is clear, force majeure is clear, and you can now relate COVID-19 also? Okay.
We're hearing a lot of sound. I think it will be better if they put questions in the chat box.
Chat box, yes. Yes. We can take your question in the chat box. No need to unmute yourself.
See a chat option in the window, so you can ask the questions by typing it in the chat box if you want to. anyone who wants to ask any questions, they can type it also.
Sir, I think you need to mute everybody. There's a noise coming.
Yeah.
Oh my God, my sound was
Amlanika, I think you have to unmute yourself.
Mute हो ऐसे नहीं आते हमें
Questions. What shall I presume? You understood everything, or you didn't understand anything? What is the answer? Okay, thanks a lot. So they're saying that they understood everything, and thanks a lot for that. I will consider that as a compliment from everybody, because definitely that will be for my benefit, right? So I think that is clear for everyone. Thanks to all of you once again.
One thing, you can see for the list of participants, some of them have not been using their actual name.
Okay.
Yeah, so like it's difficult for us to identify who's actually present in this session. So I like to request those who are using different names, because in login, I think some people are using their mobile phone, just make of their mobile phone. Oppo, Vivo, I can see that only. So like that, it's difficult for us to issue certificates also later on, because I can issue a certificate in the name of Vivo and Oppo. I will have to have the real name of the person who is attending the session. So I'd like to request those who are participating and those who are using not using actual names, kindly to share their actual names with us, so that later on I can issue the certificates to them as well. Or you can message me in the webinar also, webinar group also, the WhatsApp group that has been created. You can message in that group also. Just mention the name which you are using right now against your real name. Okay. So I guess that would be the end of today's session. Thank you, Amlanika.
Thanks a lot, sir.
It's been a real privilege, actually, and this actually for me also, this was the first time such a thing has been organized, and I'm quite also very, very new to this thing. Actually, I'd have to thank you once again, because you are the only one who have guided me all through these technical things and everything, because we are not used to this that much. Okay, so now as I have already mentioned, mean that I'd like to have an feedback on this today's session. So I'll be sharing my email ID in the WhatsApp group. I request all the participants and those who are interested, kindly send me feedback on today's program, how you like the program, and in the near future also we shall try to organize many more such webinars. I think by the end of this month, we are again one webinar will be coming, which will be presented by Advocate Mr. Abir Fukon, who is a founding partner in KMNP law firm based in Delhi. He practices in Delhi High Court and Supreme Court. So he's a founding partner of that KMNP law firm. He'll be presenting a webinar soon by the end of this month again. So I'll hope to see you all again in the next webinar that we are going to organize. And thank you all. Thank you, Amlanika.
Thanks a lot, sir. Just I have a request, a small request. Yes, just want to have a group picture, sir.
Yeah, actually, with that also you'll have to help me out. So,
definitely, I feel lucky actually, sir, that I'm getting some chance to contribute something to my teacher. That is my privilege. I consider that as my privilege, and as all of you know, Deepam sir, I will just take 1 minute to talk about Deepam sir. I have many funny situations and many interesting situations with Deepam sir. And one situation, sir, with your permission, I would like to share with everybody, if you permit me.
Yeah, please.
Yes. So actually, what happened one day? Okay, and you know, when we do LLB or when we are a student, we do many notarial things, and later on, we actually realized that okay, that was a funny event. Now I realize, and I even spoke to my husband that that's what happened with Deepam sir once. I don't know whether sir remembers that or not. So one day we had class, and sir was teaching us at that time constitutional law. Okay, so sir's class was scheduled post lunch. Okay, then sir saw me when I was going to my hostel to have lunch. Sir saw me and asked me that, are you coming back for the class? Then I said, yes sir, I will just go quickly have my lunch, then come back. Then I went, I had my lunch at the hostel. Okay, then I felt sleepy. Okay, I thought that okay, today I will not go to the class, I will bunk the class. Then I was sleeping, and that was around, I think, 1 or 1:30, I forgot. Then around 1:15 I got a call from sir. Okay, and I was so scared. So I was like, where are you didn't come to my class. I was like, oh my god, remembered. Because see, I thought that who will remember if one of the student is saying that I will come back and he is not coming back, nobody will remember, right? But that is sir who remembers all the students, and I think we're fortunate enough, sir, to get you as my as our guide, as our mentor, as our teacher, who cares so much for the students, student community. And I think that helps the students to value the teachers, to understand the morality, to understand the discipline, punctuality, everything. And that really helped me a lot. And then, yeah, coming back to the incident, then I had to come back to the class. And then again, so I lied that that day I had some incident happen because of which I couldn't come. But I was lying, and I think that was clear to you also that I was lying. But look at the generosity of sir. Sir didn't say me anything. Okay, he allowed me to the class, although with an angry face, but sir allowed me to the class. This is Deepam sir, and because of which I think all the students, I think I believe that all the students are very fond of you, sir, including me. We learned many things apart from the teaching that you delivered in the class. Apart from that, we have learned many things from you, and I feel privileged today that I'm here and you have given me this opportunity to interact with your students, and many other professionals also joined this session. Thanks a lot once again.
Thank you very much. I'm also very happy to have you today. And thank you for the remembering such a small. Actually, I didn't remember that. But I don't know how I was as a teacher, but my students, I always seen my strength, and people like you, students like you, are the real assets for any teacher. And I think when we have students like you who are doing so well in their respective fields, it gives us a lot of pleasure, satisfaction. So I think our part is done. As a teacher, I think our part is done. So with that, I'd like to conclude. I'd like to stop today's session. So once again, thank you everyone for attending today's session, and hope to see you soon, very soon. Thank you. Acha, ye photo.
Yes, please.
You have taken the photo, Amlanika?
How can, ma'am? Is it possible here?
Yes.
Yeah.
I think one of you need to enlarge the screen, full screen mode.
we will have you do with yourself.
I can take the picture.
Yeah, you do it.
Okay, ma'am.
And if any one of you can do that, if you are using laptop, you can do that, then you can do that. Yes, one is done. Yes, sir. Done, sir. I have taken the pictures.
Oh, okay.
Thank you, all the participants. Thanks once again.
Done now?
Yes, sir. Done.
So we can sign off now, I think.
Yes.
Yeah. Thank you. Thank you very much.
Thank you. Thank you, sir. Bye, everyone.
Bye.
Ending.